discussion. Love the discussion we had both in the panel and during the break as well. So I think we are going to tee up there we are, the slides. Thank you for that. Nice to see all of you here. I want to tee up our panel today. With us today, we have Dr. Olivarius. She's an American-British attorney who represents those who have been subjected to race and gender discrimination, sexual assault, among other things. And we have the benefit of her perspective here, both from the international side and the plaintiff's side. So welcome and thank you, Anne. We also have Irma Rodriguez Moisa from Atkinson Andelson, and she's also an experienced litigator, trial attorney, and she represents both private and public entities in labor and employment matters. And then you have me, much like Amy, my firm only does workplace investigations, campus sexual assault investigations. And I have the privilege of knowing Amy for many years and many others of you on this Zoom call through the Association of Workplace Investigators. And so it's a pleasure to have all of you here. And then we have the audience. We will watch and monitor the chat and try to take questions along the way to the extent we can. So our focus for the next hour and 15 minutes is really on, if you want to advance to the next slide, really about high profile investigations. And as we launch into that, maybe as a ready set, we will
Joanne, somehow you've gone on mute.
Well, how long was I on mute? Sorry about that. Thank you, David. So if you want to advance the slide, well, this is what we're going to spend the next hour and 15 minutes looking at. And that's really high profile investigations. And just as a ready set, we'll do a touch point on how all investigations are the same, whether they are high profile or not. And then we'll talk about high profile investigations, kind of do a deep dive into that, how they're different, both before the investigation starts, during the investigation, and then afterwards. So let's move to the next slide and just quickly go through. Oh, I wanted to do this quote here: when you're playing poker with the devil, no one leaves the table before he does. One of the things we're going to be talking about a lot today is the media and the press. And I am not in any way suggesting they are the devil, but this is a huge consideration that we will be talking about today, is what difference and what things do we need to be considering when your investigation is on CNN or on the front page of the paper or all over social media. So we'll talk about that. So in the next slide, we'll talk about how are they similar. And just as a kind of a fundamental premise of all investigations, this is not different in a high profile, which is you still have to meet the industry standards of being thorough, conducting a prompt investigation, reaching a reasoned conclusion using the credibility factors that we have seen set out in the EEOC and other guidances. Those are the same. We had a really good discussion earlier this morning about the independence of a workplace investigator, and that's the same. The expectation is the same whether it's high profile or not. We had a good discussion earlier too about sort of the mistrust of the independence of a workplace investigator when there is when the client is paying the bills and when there's an attorney-client privilege invoked. So we had discussion about that earlier. And maybe just as a starting point and to get the voices of my panelists going here, let's just start with that question, which is, and maybe starting with you from the plaintiff's perspective. You've had so many high profile matters and other matters that likely haven't hit the news and that sort of thing. But what is your view from the plaintiff side and even the international perspective of investigations and whether they're truly independent and how they played out for you?
We have done a lot of this, as you say, Suzanne. Independent investigations, we have found, do not appear generally to be independent. We're very skeptical of them. I don't think I've been involved in a case where I would say it is independent. I think that it's often like a McKinsey study. The CEO says, this is what I want, and that's what he gets. And I think the schools and corporations often say this is what they want, and they hire somebody and, they pay millions and they get what they want pretty much.
So in Irma, from your perspective then, what are some of the things that you talk to your clients about to increase the trust in this investigative process? How can we bridge this gap between the investigator who presumably really does want to do an independent, good faith job for their client, and how do we bridge this gap? What are you talking to your clients about?
Yeah, I think on the, and by the way, good morning, everyone, and nice to see you. I have the benefit of working with both public sector and private sector employers, and I'm able to sort of mesh sort of the best practices of both. But I will tell you that one of the ways that I work with clients on the independence is to ensure that whoever is overseeing the investigation, and I'll say the oversight of the legal counsel, that the legal counsel, him or herself, also has to be perceived as independent. So for instance, for a private sector client, and that's actually for a public sector client, it may not be the general counsel who is overseeing these high profile investigations. They may hire someone like me from the outside who does not have a relationship with the accused or the complainant, or who may not have a long history of working with the organization. So that is one thing that I always consider when I do serve as general counsel to some board of directors directly for that purpose. But I think that is one way, whether it's a high profile or not high profile case, that as an employer that we need to evaluate from the get-go of who is in fact in-house or special outside counsel to oversee the investigation, regardless of who conducts the investigation. And it can be an attorney who does it. But I think we have to give some thought to that piece of it to address the concern that has been raised that this is basically, we're just buying ourselves an investigation. So that's issue number one. And I think number two, of course, is with any investigation is hiring an outside investigator who is qualified, who has done similar type of investigation, is knowledgeable, and to the extent possible, the highest extent possible, will also be perceived as an independent straight shooter and is going to call it like they see it. So those are the two sort of pieces of advice that I think about when clients approach me, that it's me as an outsider overseeing it. I also get to have a strong, and I would like to have the sole responsibility of selecting who the outside investigator is, but many times that's not always possible. But I think those are two very important pieces.
So Ann, could I add on that, because it's really relevant. What Irma says, I understand. What we have found that if you don't know the party, so say we call up Irma or somebody and we say, do you know these people? Which of course is the first threshold series of questions. They say no, but the concern we have is that there are often investigators who work for defense firms, for instance. So there's a deep political point of view, it's a religious, it's a moral point of view, and they're being hired by the defense. And so, you know, their view is going to be not independent, it's going to be partial. There is the bias right there that we can identify. And that's very contrary, for instance, in Britain, where, you know, when you have a trial, you have expert witnesses, of course, but the court appoints one expert witness that both parties agree to. So there's not an expert witness for the plaintiff, there's not one for the defense. So you can't, you know, buy justice in that way. There's an independent one, and the duty of the expert is to the court. We don't seem to have that concept in the States. When we practice in the States, both sides hire people, and if you get an independent investigator, it doesn't matter whether you know the person or not. The fact is that there's inbred bias unless, you know, they're not used at all by defense parties. If they are, then of course they're biased against the plaintiff side to start with, and nobody hires plaintiffs, you know, objective, independent plaintiffs counsel to do investigations generally. That just doesn't happen. It's not in the DNA of the process.
If I might respond to that.
Please do, Irma.
I appreciate that perspective, and I think it's a perspective that we have to understand that the most important part we can do is create the highest level of credibility for an investigation. However, hiring an attorney who works at I'll call it more defense-oriented law firm doesn't undermine that, in my perspective, for the reasons that were discussed in our morning session about an attorney's duty with respect to the independence and what their role is. And none of us want to be challenged with respect to violating the rules of professional conduct And quite frankly, a lawyer who's hired from a defense firm also understands that, hey, this is my role for this particular client. I may never do any other work for them. And quite frankly, what I think you're potentially talking about, Ann, is a sense of there is an implicit bias that we want to confirm sort of our perspective. I personally I'm a former civil rights attorney. I was a civil rights attorney at the beginning of my career. I've obviously since then become a management side attorney. But I know that there are times I'm selected to do an investigation because I've had that perspective. I chair I'm the chairperson of a national civil rights organization as well. And so I understand what you're saying, and I think what it is that potential bias of that if you hire a defense firm, they're looking, their lens is to be defense oriented. But again, I don't buy that as an automatic disqualifier. I look at the individual, what their background is, what the reputation is. But I respect that perspective because that's why it's important to select a truly an independent investigator.
Thank you both for that. And I think what it highlights is that we still have a lot of work to do around this area, is building the trust, and what are the things that are working against the independence and the trust of the workplace investigator. So appreciate and both perspectives on that. So let's look then at the next slide and talk about the unique characteristics of a high profile investigation. And because I want to get into the weeds of this with Ann and Irma, let's just sort of do a quick overview, which is clearly a high profile investigation is different because often they are the facts of them, or at least what is perceived to be the facts, are often reported either in the news or via social media or some other mechanism by which other people have an insight or a lens into what's happening. And that then plays into, do one or both or any parties get their own public relations firms involved in it? How then, when it is this high profile, do we work to maintain this independence? And yet, as Mark termed it, I like this, having professional communications, even with this independence aspect. Often a high profile investigation involves very high level executives. And often with very salacious facts, sometimes what we refer to as disputed conduct as opposed to disputed motive. And then sometimes it touches on kind of more systemic issues. Often when you're dealing with a high profile investigation, it goes beyond just the claimant who's raised an issue. They can point to more systemic issues, more cultural issues that are all over the organization. So with that backdrop, then I'd love to hear from, we can go to the next slide, and I'd love to hear from the two of you about maybe starting with the question related to the high profile nature of it and public relations. And these are considerations before the investigation occurs. And I guess I'd like to hear from you first on this point. What do you advise, if anything, your client about going public with their concerns in the organization and their experiences as to what happened?
Well, I mean, public relations obviously is another way to get justice if you think the system is slow or it's not working. The problem is the what we call the Johnny Depp problem these days, that you go public and of course you get slammed with a defamation suit. So we need to file first our action, and then within the four corners what we filed, assuming that it was nothing outrageous or malicious in it that we knew, but that it was a fair filing. We put a lot of description in the filing. We tell the whole story in the filing. They're lengthy filings. And then we launch a PR campaign on the back of what we've got in the filing. So we are immune to a defamation suit.
And Mari, do you want to advance the slide for me, please, here? And so in your experience, and then, well, let me ask you this. Would you advise your claimant to go public and go through the process that you discussed before you've communicated with the employer? Do you typically have communications, and when that is not successful, then you go public? What's your process there?
Yeah, this is a British versus American law question, actually. In Britain, as a solicitor, I'm obliged to send across a pre-action letter, they're called, ALs, we call them. It essentially says that I'm going to sue you, and this is why I'm going to sue you, and then you can do it in a page. We typically do it in maybe 30, 40, 50 pages. We lay out all the facts. We tell the story. Very different than in the American, filings that we do. And then we wait to hear from them. And of course, in Britain, if you lose your case, you're going to be paying fees to the other side. You know, they have to pay. The loser pays in Britain. So you have to do what you can to settle the case. And everybody involved in a case is obligated legally and financially to try to settle a case. So you send a pre-action letter over, and then you wait to hear, and then you issue proceedings if, you know, you can't get anything. Now, in Britain, we don't use the PR tool very much. We pretty much stay quiet. When it's sub judice, we just leave it. After it's done, then we can go to the press. In America, we do the same form. Our formula is that we do a pre-action letter, and it's very detailed. There's no question about it. It's, you know, we do very, very detailed pre-action letters, so there's no doubt. We run through our evidence. We do a lot of investigation up front, and then we wait to hear from them. And then if we don't hear, then we file and we do a PR campaign in most of our cases. It depends the nature of the case, but then we'll do a PR campaign. So it's somewhat different depending on what country we're in.
And one follow-up question for you on that. When you talk about a PR campaign, is it primarily the press, or do you use social media, a combination?
Yeah, we have used Twitter. Of course, Twitter is becoming a very poisonous platform quickly. How long that will even stay in business is another issue. But we've used social media, absolutely, and judiciously and cautiously, but we have done that. And then, of course, you know, we use the press. We do a lot of interviews over film, you know, on the television. You know, we do all that also.
And when you do go to the press, do you allow your client to have interviews with the media? And if you so, how do you anticipate the media questions?
Yeah, often our clients prefer not to be interviewed. And we're cautious about that in America because we want to make sure that the interview is very defined. We don't want the person getting a really excellent journalist who's going to make them really comfortable and then get all sorts of information out of them, which we haven't handed over in discovery yet. So we have to be cautious. We have to educate our people. And then it depends on what kind of case it is, what we're trying to do. Is it a social justice case? We want to get the message out. And does the person, are they comfortable speaking? We do a lot of sexual assault cases, sexual discrimination cases. And we do a lot of high profile people, and sometimes they want that coverage and other times they really don't want that coverage, and we may do it through our lawyers or do nothing.
So Irma, from your standpoint then, and you're advising your clients, if you have, what is your PR strategy in a high profile investigation?
Yeah, so I think that from the defense side, we should understand sort of what the interests are of the organization. So we have sort of three interests that we want to preserve. And this, I think, guides at least the initial press strategy or social media strategy, public relations. I think interest number one is maintaining the values of the organization, preserving morale for all of our employees for once this news hits of this high profile allegations. And so I've got to think of that. What is, you know, I need the bigger corporate entity consideration of maintaining that we don't want to get sidetracked and deviating from our mission, but also maintaining employee morale. Second, we also have the sort of the two legal considerations, which is one, the due process to the accused. That is, that these are simply allegations at this point in time, and that person who's been accused should be given the opportunity to respond in the investigative process to those allegations and provide their version of events or denials or whatever it is. And then lastly, again, on the legal side, is to protect the complainant because they are engaging in protected civil rights activity by making the allegations and obviously alleging that we have not fulfilled our obligation as an employer to provide a workplace free of discrimination and harassment. So as I look at those three interests that I have as defense counsel, generally speaking, what I do on the public relations side is, number one, I always tell the client, let's get an expert, communications expert. I'm a lawyer, and while I have common sense about what I think might work well in a public relations campaign, that's not my area of expertise. So I never pretend that I know all of what works, what doesn't work. So I want to retain someone who actually is an expert in that area. And then the focus for me, secondly, with whatever the press statement is the following. I want to ensure to the public and to, again, these other, the complainant and the accused, that we're committed to this process. So I always ask the outside consultant, let's develop a statement that says we're going to be retaining an outsider, we're retaining an outsider, we're going to let that process work out so that there's a public commitment to this investigative process. And then the second thing that I always want to have done is that the public relations statement reiterate or repeat our commitment to our core values as an organization, that we do not tolerate discrimination or harassment, and that we will take corrective action depending on what the investigation results show. So those are my interests, or my strategy with respect to dealing with campaigns to deal with stuff in the media, to try to address those three interests that I described: commitment to the process and commitment to our core values as an organization, that we do not tolerate discrimination or harassment. So those are the things that guide me. And there are times that as a result of that, there is no comment, or we're waiting for the result. And I will tell you that the more challenging piece is that the individual who's accused wants to go out and make statements. This is a disgruntled employee. This is somebody who, but it's whatever it is, completely untrue. And nobody's happy with anybody with those kinds of comments, I will tell you, except for my internal folks who are like, okay, let's get focused on what the work is that the organization has to do. But the complainant's not happy, and neither is the accused. Just FYI.
So, and let me speak from the investigator standpoint. It's obviously we do not comment, and we don't have a communication with the press about it, because we are typically under the attorney-client privilege. I would say from the investigator standpoint, really the only interest we have when something goes public is to know that if somehow some part of our report will be released, to really be careful that there's not something in the report that will act as a soundbite that, taken out of context, is incorrect, or gives a lens into something that's just inaccurate. So really, my approach to these usually is read the report for one purpose only. Is there a soundbite that could be taken out of context that could be harmful to either side? I don't mean sides, but it could be harmful to either the individual who's the subject of the investigation or the individual who's raising the concern. So I'm interested from both of your perspectives. That maybe there's two questions that are burning here. One is, what if the press gets it wrong? Because the reality is that they have limited visibility into the investigation typically. And the reality is that they don't always fully understand the investigative process. So what happens if the press gets it wrong? Do you take any action? Do you do anything with that? Maybe Ann, I'll start with you.
Yeah, we certainly do. If the press gets it wrong, we do what we can to get them to correct themselves, and there are processes for that. If they will not do that, and they don't do it effectively, then in addition, we might go to other press people and release a press release or do something ourselves. We might put something out on social media, on our website, but we really try hard to make sure that the press reports things faithfully. And generally, they do. It's very rare when we've had a problem.
Irma, any thoughts?
And I would agree with Ann here. I think all of us have an interest that the press gets the findings correct. Obviously, we also are concerned on the defense side for defamation claims on either side. And so as an employer, we may have greater obligations to send official communications to the press to get it right with respect to protecting reputations of our employees.
What are some of the things, and this to me is really kind of a fundamental question to this program, really, is what are some of the things you might do in a high profile workplace investigation that you would not necessarily do otherwise? And the purpose of it really is in many ways to manage the reputational harm or anticipated public criticism of either your client or the process. And maybe we'll start with you on that, Irma.
Yeah, so again, on the initial piece of it, I do advise that we stay, I'll say, more muted as to the substance, that we're going to focus on process and being committed to the process. And so if I continue to do that with my client, the impact on reputational harm for anyone, I think is is minimized, because at that point, there shouldn't really be that many comments. Even in the light of a potential plaintiff's attorney, the employee's attorney, making some pretty egregious allegations, the comments might be, these are allegations at this time. We ask individuals to, or, you know, we are not going to try this matter in the court of public opinion or in the press. And so please allow us time to allow this process to work its way out. Now, we're going to get to a slide about what happens after the investigation or during the investigation when information comes to light that the allegations are true. So I'll wait for that one. But ultimately, then the message does shift if, in fact, the investigation substantiates, sustains the allegations. But for purposes of reputational harm, again, I focus on the process. And certainly in California, we know participating in an investigation, making a complaint is protected activity, and statements made in an investigation are not subject to a defamation cause of action. So I also have to be considerate of that. I can't file an anti-SLAPP motion because someone made allegations in a complaint in an investigation. So again, I'm a little bit more limited, I think, in California.
And is there any change in your strategy in a high profile investigation as opposed to one that won't necessarily go public?
Yeah, well, go public. I mean, that goes to the issue of how do you conduct these investigations and what's fair and what achieves justice? How do you get justice in America? And that's a tough issue these days. We always ask for the investigations to be public, and the report should be public at the end. And we get to review the protocol. How did it get conducted? Who did it? Who do they interview? Do they interview a fair set of people? You know, is this a fair outcome? And so we want to see the process. And we don't need to see everybody's testimony, but we sure need to see the overall report and what gets released. And of course, you know, people don't have a whole lot of faith in investigations that aren't, you know, public in that way, at least. Why would you have any faith in it? If it comes out for you, fine. But, you know, they're very hard for plaintiffs to get good results in, we find. And, you know, as our experiences, I've said, you know, people buy these reports, and that's what justice in America is often about. So we want to see the process. We have grounds to know if it's fair or not.
And, you know, it's so interesting too. So from the investigation side point of view, that's where some of the tension is. In my experience, when an investigation is in the news, or it's high profile, it's in social media, whatever it might be, often the witnesses are even more reluctant to be candid, be forthright, because they don't know what's going to happen with what they say. I mean, I think we start with the premise that in most interviews, we already know the individual is going to be somewhat reluctant, particularly if they're witnesses. Often the complainant really wants to be heard and share their story, respondent as well. But witnesses are often reluctant as just a fundamental premise. Then you add to it the high profile nature, and they're even more reluctant. They don't want their statements to be made public, or it makes it even more difficult for them to say something that might negatively impact a colleague. So there's that tension involved in it too. Is that a consideration for either one of you? It may be with you, Anne, that there's any sort of chilling to this witness statements as in a high profile matter?
Yeah, I mean, you know, most plaintiffs are not fighters in our experience. Bad things happen to good people, and then they want justice. How do you get justice in this country now, particularly in the, you know, post-Trump? Well, I wish I could say post-Trump days, maybe not, but in this time, political time, how do you get justice, and how do you experience that? And, you know, people who have been harmed, they want to have a chance to access the system. If they have to go to the legal route, then they want it to be fair. And how do you prove that's fair? How do you give them a shot? It's really tough on that. And so these investigations, you know, you want them as open as they can be and as balanced. And you'd like the, you know, it'd be very nice for the plaintiffs. I've often said to investigators, why don't we get to choose an investigator? Why don't the defense side choose an investigator? And then we get somebody who's genuinely in the middle, and have the 3-panel do the investigation, and then let us see who you're interviewing and make sure it's fair and balanced, and let's go through the process, and then let's see the report at the end. And people don't want to do that. and it's not about cost, because these things can cost a fortune. We sued the University of Rochester a few years ago, and instead of just settling, which they could have done for really minor money, less than $1 million, certainly, these 9 plaintiffs, most of them very senior faculty at Rochester, they went forward, and Rochester hired, Deborah and Plimpton, and they paid them $5 million+ to do a report that said that there was no violation of law, that was improper behavior, but it wasn't so bad and it wasn't a violation of law. We argued the opposite. Judge Villardo came down on our side robustly and knocked the report out. Florian Jaeger, who was the, misconducting person on the faculty, he just contested it. He keeps citing the Mary Jo White report at Debevoise and Plimpton, but it was totally invalidated. And they even found more misbehavior than what we knew about, and they reported it. But that an institution would pay $5 million+ to have Debevoise come in, investigate. This is a educational institution. Where do they get that kind of money to spend on something like this? They ended up settling with us for $9.4 million. And now still, because they haven't fired the professor before, because he still is, stirring the pot, they still have lots and lots of trouble. They did a restorative justice process afterwards. And of course, restorative justice only works when you take accountability for your actions. And Florian Jaeger is not about to do that. So, it continues. It just goes on and on. We estimated that the cost to the University of Rochester in this matter, which could have been under $1 million, cost them nearly $50 million. By the time you saw the faculty who left, all the contracts they took with them, the recruitment, the lack of money giving, the alumni not holding back donations, and then having to replace, we got the president fired. Okay, this went on and on, plus our settlement. It's very sad. And I think if educational institutions understood what things really might cost them, they might do prompt investigations, not go to the defense firms and pay millions and millions out, for what? Now, they did have to publicize the report of Mary Jo White, but, our plaintiffs, for instance, they couldn't participate because we're in an active litigation. So the report was without any merit. You don't talk to the people bringing the claims and, evaluate their evidence. What good is that report? But they still went ahead with it anyway. It still paid over $5 million. So, I think that people don't understand the economic costs of doing investigations and then the consequences of those things. We're lucky Judge Villardo backed us up to the hilt. And they're still sad about it. And it was so unnecessary to waste $50 million on a process that, they didn't have to go through.
Thank you for that perspective, Ann. And to David's comment in the chat, one of the plaintiffs is now a professor at Berkeley and a member of the center. So thank you for that. Maybe, so let's look now.
Wait. I think I need to respond. There was a lot to unpack in that response. Okay, so I think one of the questions that Ann posed is sort of what is justice and how do you get justice in California or in the United States? Okay, so what I'll share with you is that certainly in California and under Title VII, the Fair Employment Housing Act and Title VII tell us, in essence, sort of what our legal duties are as an employer. And I think in some respects, it does get to what is justice, right? What FEHA tells us and Title VII the cases tell us is that an employer has a duty to create a work environment that is free from discrimination and harassment, and that our obligation is to take appropriate corrective action if there is in fact a sustained finding of behavior that would constitute a violation of our policies or the law. And how does Title IX and Title VII, pardon me, and FEHA define what's appropriate corrective action? Well, they look at it in two ways. And one is, what action did the employer take to send to the rest of its employees that it in fact does not tolerate harassment or discrimination? And then number two, what actions did the employer take that was reasonably calculated to ensure the conduct didn't occur again? So to prevent it from occurring again. So these are the two frameworks from which I operate when we get an investigative report to say, what did we do? And of course, in answering question number one about what actions did the employer take that were reasonably calculated to send the message to the workforce that we don't tolerate discrimination and harassment, of course, number one is doing the investigation. And it sometimes means placing somebody on leave, or it may mean some additional training, but that's part of what the framework has been set under our federal law and our state law. And so, of course, our system of jurisprudence in the United States is that the other piece of this, of course, of what is justice, is potentially monetary awards for compensatory damages or punitive damages, obviously, if in fact it's shown that there's a pattern in practice that the conduct was if it meets that standard. And so it's a harder question to answer in the abstract, because we also know from taking depositions of plaintiffs that what many of them say they want is they want it to stop, and they want to make sure the person who did what they believe happened to them or did happen to them doesn't do it to anybody else. And so that typically means terminating an employee. Okay, so what does that do for us as an employer? Well, the law places us in a situation where it's our obligation to basically take those steps to ensure that we send the right messages. So the law places the obligation on the employer to conduct the investigation. And we can decide, even for a high profile, it's going to be done internally. No one will believe that's independent. And so then we choose to go outside to allow for that independence to somebody who's not connected to the institution, who doesn't have pre-existing relationships, who theoretically at least doesn't have preconceived notions that they've prejudged a situation. And I think that system works. I understand Anne's perspective that there may be some employers out there who basically want to buy a certain finding. I get that. That hasn't been my experience with my clients. And I don't know if it's because of me or whatever, but it's not been my experience. But the law imposes that obligation on us. And so I think it's appropriate for us to hire the outside investigator. And then in terms of some of the transparency issues about what's appropriate corrective action, I mean, we can take a look at make-whole remedies if the person lost out on a promotion. If during the investigation it's sustained and the employee says, look, there was also this additional trauma that occurred to me. I have no issue considering for clients, is there some sort of compensation for the emotional distress, the non-economic damages to make this person whole? That's the whole purpose of the take appropriate corrective action obligation we have as an employer. We'll talk in a second, I think, about the transparency of investigative findings, and I'll have some more comments there, but I do want to make sure I respond to that. The law in California under the Fair Employment and Housing Act, under Title VII, the case law tells us we have an obligation to take appropriate corrective action, and they've given us the two tests, the two elements that we have to satisfy. And I don't know if that's exactly justice, but it's part of justice at least. And I need those investigative findings in order to terminate someone. Many of our clients have some level of due process, or they'll have a good cause provision in an employment contract. And I've got to do that investigation. If my investigation comes back and says it didn't happen, then of course, what am I saying? Yeah, we'll talk about that at the end. But I do think that we have to give the benefit to the fact that our state legislature and our court have developed a framework for how we define what justice is.
Thank you. Thank you, both of you. All right, let's move to the next slide and get into some of the nuts and bolts of considerations during the high profile investigation. And I'll start with you. You had talked earlier about the investigator who proceeded with the investigation, even though they didn't have an opportunity to interview the claimants because they were in active litigation. What do you consider when you're advising your client about whether to participate in an interview, and does it make a difference high profile versus more routine type of claim?
Well, what we prefer to do ideally is actually to create a mediation situation. With investigations, I understand the need for that kind of tool in law. But for instance, if you have a mediation, we really look forward to those because we always put forth a mediation statement. We always share them pro forma with the other side. We ask the other side to share theirs with ours, and we go through the facts as each side knows them. And very many times, without spending a whole ton of money and doing a big investigation, the truth becomes pretty apparent. And it's very rare if people come in good faith to mediation that we can't resolve things. So I think that it makes more sense to do a mediation first and to have that mandated to do. And then if that doesn't work out, then we may need to do an investigation, and a very often a very specific, focused investigation and not a widespread thing. But once you realize what the issues are, focus on what the issues are if they have to be investigated. But if not, I think mediation can resolve things quite splendidly and effectively, and people walk away feeling that they've talked to each other's side. A lot of healing happens in the process and understanding. And we usually walk away shaking hands with the other side and feeling that it was a good day or days and that we've got good outcomes. So I would recommend that. I would undercut the whole notion that you have to hire an investigator.
Irma, what would your response be to that request? Let's hold on the investigation. Let's do a mediation and see if we can resolve it that way.
I'm always open to that. Again, I've got also institutional interest, as you can imagine, as the representative of the employer. And if we can make a resolution that's mutually agreed to, I'm always open to that. Obviously, I'm only going to have my perspective on it until I get Anne's mediation brief. And obviously, similarly, I think in a mediation, I don't have an issue sharing my mediation brief. I do think that results in better outcomes. And at the end of the day, it always comes out anyway. But I'm open to that. That is not a non-starter. And I think every employer should be open to it, unless there's some other factors that are unknown at this moment, that maybe there's a sense that it would not be conducted in good faith.
So from the investigative standpoint, I'm interested in both of your takes in terms of, because one of our obligations is to conduct this not just thoroughly and independently, but also promptly. What implications would that process have on the timely nature of the workplace investigation?
Can you say that again?
Yeah,
I was reading one of the comments here on the chat, so I apologize.
Sure.
I didn't.
Yeah, I'm just interested in your perspective, because I think I understand the value in what you're saying. I think that's correct. That if you can resolve it through a mediation, that would be helpful. From the investigator standpoint, one of our requirements is to conduct it promptly. Any concerns about of our duty investigation mediation is going? In other words, if there's a mediation, sometimes that can take time to get scheduled. Sometimes it would just delay the investigative process. Thoughts on that?
My initial reaction to that is that if it's a request made by the complainant, there's not going to be, there'll be some sort of agreement or communication that we are putting a pause on the investigation while we engage in mediation. And I don't see the legal exposure on that side. Obviously, the accused may not be as thrilled about it, but nonetheless, if we're trying to get to a resolution, I'd like to think that if we're all participating in good faith, it becomes a moot point at the end of the day if we're able to reach agreement. So I would certainly just want a written agreement that we've agreed that given the pending mediation, that we have put a pause on it. And of course, I'm not talking about a mediation that's going to occur in 6 months, 7 months. I think the mediation has to occur as quickly as possible, and no later than within 30 days if we're going to do that. That would be my own personal sort of test of, can we get a good mediator in that the parties can agree to within 30 days, and then I think we can satisfy that concern. If we cannot, then I really have to talk to the employee's attorney to say, how much longer are we going to wait, and are you willing to wait? Because it's our obligation, but it's also your right to have it prompt and thorough.
So let's get to what Irma, excuse me, Anne, did you have a response to that before I move on?
Well, the prompt is such a key thing. I'm glad you've got a slide on that, because, justice delayed is justice denied. And that's what we find all the time. Certainly with Title IX cases, I would say almost my strongest critique is that educational institutions take so long to get their act together. And I think they should be penalized for this. I think there should have to be deadlines. And if they don't meet them, there should be money penalties, because once there are money penalties, then all of a sudden things will change. They can go on a year, they can wait, the trauma that they induce in people and the internal battles and the heartache is really considerable. And this is a real big problem in the Title IX investigations. In corporate investigation, Title VII, we find that's different, because somebody's been accused. Usually they want to be, well, if they're guilty, they'd like to have it delayed, of course, for a while. But if, often they want just to get this done. It's not commercially fun to have these things, or it can really affect morale, as Irma has said. So it's a little bit different, and they have a different motivation. If they think they have to pay a lot of money, then of course there's a reason to delay. And sometimes these things, do require a whole lot of money. They always claim that their insurance carrier, is holding things up, and that's a problem. And we always say, well, that's for you to work out with your insurance carrier. And, you have to settle with us, and that's your problem, not ours. Often it becomes our problem, though, because they make it our problem. So, prompt investigations, thorough investigations. I've always thought these sexual assault issues, particularly at universities, if the university decides that it's in their interest to not have this problem, and the law makes it so that a victim's interests are aligned with the university's interests, then the university will take a different position and they'll work hard to stop this. And I think they can stop a lot of the rapes and sexual assaults on American campuses. We know it's a huge epidemic of a problem, but we have to align the interests of the institutions with those that are victims. And right now, there's no alignment. They see it in their interest to hope the problem will go away, to beat up the victim, to delay. Under the new rules with, Betsy DeVos, the accuser has to meet with the accused. And there's a lot of non-trauma informed ways of handling this that she's put into place. These are now not being adhered to so much. But I think if you were to assert monetary penalties against an institution, the whole world would change, and rape culture at these universities would decline rapidly. I don't think there's any question about that. We've sued Yale a number of times, for instance, and some years ago, Yale was assigned by OCR with a bill. They got something, I can't remember the exact amount, but maybe it was 100,000 plus or something. And they were so insulted and arrogant because, Yale's a great educational institution. They shouldn't be held to account, is their view. And so in practice, they then challenged that. They spent a lot more money challenging it than they got it reduced. But it was a clear demonstration. They still had to pay $85,000 or something for the violation. They spent more legally on getting it reduced than having to pay it. But it showed the sensitivity of a university. We need to make laws that align the sensitivities with the university, with justice, and with people who bring complaints to make sure that those complaints are founded. If it's true that, somebody, a man or woman, was raped, sexually assaulted, whatever, on a campus, and there was notice to the university that this is a problem, then they should have to pay. They should have to pay large sums so they're motivated to stop this problem. And that's not happening.
I would agree that our institutions of higher education seem to take the longest to complete an investigation based on personal experience and also the observations of other investigations. I have a sense as to why that is, primarily because institutions of higher education are very process oriented. There's a huge level of review that goes on with draft reports. And so I agree with Ann that it really just takes too long. The solution, I don't know necessarily what it is. I have some ideas. We know that for our police officers, they're subject to the Public Safety Officer Procedure Bill of Rights. We have a 1-year statute of limitations there, that if you are going to discipline or take any punitive action against an employee, it must be issued within 1 year of the incident occurring or from when management reasonably knew of the allegation. That certainly moves things along. Query whether 1 year is too long, but nonetheless, at least that gives some of my public entity clients a sort of a guidepost that it can't take longer than that. The issue of monetary sanctions, I think that certainly would motivate, I think, a number of clients to get it done sooner. The challenge in California would certainly be that you can't have sanctions or punitive damages against a public entity because sanctions are generally intended to send the message that this wasn't acceptable. And the public policy of the state of California is that sanctions paid by a public institution don't teach anybody any lessons because it's the taxpayer who's paying that bill as opposed to any individuals. So we might have to have a different workaround from that for our public institutions. But I certainly agree that our institutions of higher education take the longest to complete investigations for a variety of different reasons, and some of which I think we can address, and some of which I think because of the nature of who might be accused, if you have a faculty member, the due process rights, et cetera, might be an issue, but agreed. And I always agree with the notion that justice delayed is justice denied. I have no interest in delaying issues if I've got to take corrective action. But I will say that there are times when it is delayed a little longer. It gives me more time to formulate whatever we're going to have as our ultimate corrective action as an institution.
So I want to touch now on a topic that was really talked about in the first session, and that's the attorney-client privilege. And we heard, we heard Mark walk through the duties, and I thought that was extraordinarily helpful. And maybe starting with you, Irma, on that, what is your approach to whether an investigation is attorney-client privileged, and is it different in a high-profile investigation versus a routine one?
It is different in a high-profile investigation because the report and its findings are going to be subject to even greater scrutiny or criticism at the end of the day. And so I am a proponent of attorney-client privileged investigations because as an advisor to the employer, I want to be able to have the first look at what the findings are, being able to fashion the corrective action, and have the ability to waive the attorney-client privilege. And the reason for that is for, I think, confidentiality purpose, best information, and again, as a management side attorney, to be able to manage our risk. I recognize that desire on my end certainly creates confidence issues on the part of the employee and the employee's attorney, because they're wondering, what is it that I haven't told them? What am I holding back on? But yes, I'm a proponent of attorney-client privilege investigations, and it is a big discussion that I have with clients before the investigator is retained. And there are quite a number of times that we do waive the attorney-client privilege, or we have the investigator prepare an executive summary that at least preserves the confidentiality of the identity of witnesses and provides enough information about what the findings were and the reasonings for the findings that hopefully will satisfy the concern about transparency and the findings.
Of course, if you have the label attorney-client privilege, and I understand what you say, Irma, there's a lot, to be said for that. But we face situations where often corporations, even at the schools, people lie. And if they have confidentiality and they go in and decide to lie, then you have outcomes that are not justice orientated. And we see this with some frequency. We have a case right now of a prominent Silicon Valley firm that our client is a whistleblower, and the client really cares deeply about the firm. He lives and breathes this firm. He's one of the senior people in it, and he wrote a letter to the board. And the board then hired the Paul Weiss firm and to do an independent investigation. So, the employee goes, who is fully devoted to this firm. He speaks for 8-9 hours with the Paul Weiss firm, and a couple of days later, he's fired. And it is really, it's a sickening occurrence because there's a lawsuit they filed against him. This is a good man. He's done nothing wrong. This will fall under, we'll bring an anti-SLAPP action probably, and we'll go public on this in due course. We're just figuring that out now. But, we didn't get to see the report. What did they say to the board? And what the board was doing was just trying to figure out what they could do to silence this guy, what they could do to avoid dealing with the problem. What do they do about that? And it was done, we think, all unfairly and not the American way, and it didn't adhere to justice. But this attorney-client privilege thing is, they say, well, it's attorney-client privilege. Well, hold on, you told us it was an independent investigation. Why don't we get to see the results of the independent investigation? You talk to our client. They didn't talk to a lot of other people who might have made sense to have spoken to if they were really searching for the truth. And it was just a chance to get whatever they could from the whistleblower and then beat him up. So we see this. And then in a related litigation this firm is in, we know for a fact because our whistleblower knows of various things that should have been turned over in discovery in the other suit. And of course they weren't. So here's a block on discovery. They're not responding. And of course, the people in that lawsuit don't know what they're not getting. We know some of what they're not getting because we have related matter. It's really very frustrating to see the standards of truth, that truth is not governing this particular business. And we see quite a bit of this kind of thing. So it's very sad and disorientating, and attorney-client privilege is used to, as a weapon. It weaponizes the whole process. So I'm really worried about attorney-client privilege, and I don't know if you can get to hide behind that. I don't know if that's fair.
And Ann, I appreciate that. As I said, I appreciate that perspective. And what I will say to you is, on the employer side, in many respects, we're caught in the middle when you have two people who want to battle it out in a public setting, whether it's both making a presentation to the board of directors, the board of trustees, or to the media, right? What I see a lot of now is that individuals who are accused of this misconduct, they then lawyer up. They then decide they want to be very aggressive on the public relations part. And I can't put a gag order on both of you. I can't, I mean, you're going to have some free speech rights to make the allegations and to respond to the allegations. And so I, as the employer in those circumstances, am caught in the middle where I'm trying to manage our messaging while these two individuals are having a very public battle. And then I'm managing, as you can appreciate, I know, a board that has very diverse interests and potentially has their own sort of perceptions of who's right and who's wrong. And so this is why the independent investigator coming in is critical, to be able to sort out and give me, as outside counsel or as general counsel, whatever role I have, a sense of what really happened, so that we can carve what is the appropriate corrective action. To the extent that that has been your experience more regularly, I will say to you, with the example you gave, that's certainly not been my experience. I work really hard. Obviously, I'm more centered here in Southern California than Northern California. I don't advise tech industries, the tech industry, so maybe it's something that's particularly there, but I do know, of course, that there are very aggressive defense firms. But I will tell you that at the end of the day, an attorney-client privilege investigation, if done right, will result in the right outcome for all. And if it is being used as the weapon, I think you are left in the situation as representing the employee that your only recourse at that point is to go to court and do the discovery battles. And at the end of the day, as you know, the investigative report, certainly in California, doesn't come into evidence. There may be the operative fact that their investigation was done, and then the employer took action based on that investigative report. But it is very clear from case law and jury instructions that ultimately what happened is within the purview of the jury. And that's why courts do not allow an investigative report to come into evidence. One, it's obviously hearsay, and two, it's the province of the jury to determine what happened. I think, and then of course, if it's attorney-client privilege, you're going to be able to argue you can't use it at all. So an employer has to make a decision. Is it going to release it or not for purpose of litigation exposure? Because if you say you're not, you may not be able to use that as a defense, bottom line. And at least that's the case law in California.
Thank you.
Understood.
And I forgot
My
about
concern is,
I wanted to add one thing about, and maybe it comes at the end. So I'm sorry, it's about what happens afterwards. So I'm sorry, go ahead.
No, I'm sorry. I'm just concerned. I've just done a trial, and in Illinois, and it is you have to make sure before a jury can make a fair determination that they actually get the evidence. And of course, it's really hard if you don't have people turning over the evidence they should, which I think is often routine in many cases. You have to fight hard all the time with big firms. We're having discovery battles, and we only find things out when we're reading, layer on layer of social media or text, and we say, wait a minute, there's clearly a gap here. They flood us with millions of pages of documents. It seems to me more and more so that, at least in certain defense firms, the civility of being a lawyer, that's not happening. And we're accustomed to having good relations with opposition counsel. We often become friends with them. I mean, in that lovely way of working with someone. we find increasingly with the defense firms, they're angry, they mean, they start off. I just did a deposition last week in New York, and it was really sad to see how angry the counsel was. And this is from a reputable firm in California, really demeaning. That's the approach. And we see this increasingly with defense firms, and they're not turning over the discovery that they should. And they feel self-righteous about it, like that's fair game. It doesn't give me a lot of faith in the American justice system when they don't follow the rules. So it's all well and good to say the jury can decide, but the jury has got to get the evidence, which often we're denied. That's a problem.
And I would agree with you that that's not acceptable. That is not an acceptable standard for us as lawyers to engage in. Am I opposed to a hard deposition where we have hard questions? Absolutely, I'm not opposed to that. But being dismissive or demeaning to an individual, I agree, is not part of the civility. I can be tough on witnesses, but I don't have to be disrespectful and making snide comments, etc.
Yeah.
I respect that.
Thank you.
Thank you both for that very informative discussion. I would like to move to the last slide now and just pitch the question to both of you. Okay, now the investigation is complete. And Irma, you now have the investigative report. What considerations are you taking into account as you're advising your client?
Yeah. So one of the things that is absolutely critical is that once the investigation is in fact complete, you have to provide notice to both the complainant and the accused as to the generalized findings. And so one of the things that I carefully take a look at is how do I craft the notifications? And so, and the beauty of being able to do both public sector and private sector work is that I can compare some of the requirements. So if you look at California Fair Employment and Housing Act regulations, they have a fairly generic statement about what you're supposed to tell the complainant and the accused. Certainly the statutes don't provide for it. I think even the EEOC regulations have a very, I'll call it not useful FAQ on what you're supposed to tell the complainant and the accused. But what I turn to many times is what we'll call the Title V regulations that apply to our K through 14 institutions in California, which is our school district and community colleges. And the Title V regulations do require that when there is a discrimination or harassment complaint or retaliation, that the entirety of the report be produced to both the complainant and to the accused, and that it be presented in closed session to the governing board. And the governing board then decides if they're going to accept the report, not accept the report, request further investigation, or ask further questions before they'll accept or modify it, etc. And so going to Amy's point here is that level of transparency, I will tell you initially when I handled that many years ago, I was like, well, we're going to let everybody see. It has resulted in more resolutions of issues at the community college level, because I've represented community college institutions, than not. And so everyone's able to see everything. The employee is able to criticize it if they want. They have a right to make a presentation to the board, so does the accused. And then everyone knows why you did what you did. And so what that informs me is that, and I have to tell, if I'm going to keep it attorney-client privilege, I nonetheless have a duty to inform the accused and the complainant what the findings are, in at least in a generalized way. If I'm going to base a termination or discipline decision to the accused, I do have to provide them, as a matter of due process, more details, and then I may have to get a partial waiver of the attorney-client privilege, and that has to do with the waiver that I asked from my governing board that basically says, in order to comply with due process requirements, that they waive the privilege as to the report so that appropriate corrective action can be taken. So that is a big part of the consideration. What do you tell folks? I'm going to let Ann comment on that, and then I'll come back to how do we deal with our institutional clients, our stakeholders, our employees, and what information goes to them. But I've been going on there for a few minutes.
You've been going on very well, eloquently. I agree with the essence of what you're saying. I think we're in the same place on that.
So then the question becomes, and I know Ann and I will have some probably disagreement here, is what do we tell the press? What do we tell our other employees? And normally, because of privacy considerations and the fact that you've got two privileges at play in these investigations potentially. One is the attorney-client privilege, which we discussed that only the client can waive, but you also have the right to privacy and confidentiality. But what that means is that the privacy obligation is not absolute, unlike the attorney-client privilege. The privacy privilege says only those with a quote-unquote need to know the full results of the investigation can have access to the full investigation. And then you have the issue of witnesses who came forward and basically were told that to the greatest extent possible, we're not going to release your name, we're not going to share your information. They have a reasonable expectation to privacy, but it's also not absolute. Because again, if we're going to discipline, particularly a public employee, a professor, a dean, a police officer, they have due process rights to know who their accuser is and have us prove the allegations subsequently in whatever administrative proceeding they're entitled to. And so we can't make that absolute. And so many times what I have to consider is what is that need to know? If I haven't done it as an attorney-client privilege, I still may not, and even the Title V investigative report does have redactions for witnesses or witness A, witness B, to allow for the confidentiality of the witness statements to preserve their expectation to privacy. And so this becomes, I think, the bigger crux. And when it is that I would request from an investigator to please prepare an executive summary that I can release in its totality to the public. And then I'll add one more wrinkle, which is the Brown Act and the Public Records Act under the state of California, which is what documents that the public pays for out of taxpayer dollars are subject to disclosure. And the Brown Act does not have an explicit privacy privilege in it. It does recognize the attorney-client privilege. And so privacy, confidentiality privileges is governed by what we call a catch-all provision, that any other circumstance in which the agency believes preserving the confidentiality of the document would be in the public interest. And what courts have held is that when you have a high-level executive or high-level public person, that the interest of releasing the totality of the report, if it's only based on a privacy privilege, the interest in releasing it outweighs the interest of it being kept confidential. So when I have a high-level public official who's accused, under those circumstances, it is very likely that that report is going to be made public. So in some respects, that makes it easier for me. It's my private sector clients that struggle more because they don't have that obligation.
Anne?
Well, for me, the confidentiality issue, the attorney-client privilege, I think it comes down to how bad is the actor? What is it about? You know, Harvey Weinstein, it would have been helpful to have gotten that stuff out on him sooner than later. You know, Prince Andrew, you know, we've touched on all these cases. And it seems to me, Ghislaine Maxwell, all this stuff, we want the word out there. We don't want to give them confidentiality. You know, we think that they've lost it by their actions. So I think it depends what the problem is. What we know is that people who rape, for instance, you know, they tend to do it 6-7 times. It's a repetitive thing. We know with priests, we know that you pass the trash with all sorts of people who act inappropriately and poorly, that it is that sort of pass the trash thing. And we think that it's got to be made public as to what's going on, or there have to be other laws. Like, for instance, to get another job, it has to go in the personnel file, what's happened, it has to transfer with them. The institution has a due diligence right under law. We'd like to see to make sure that they check and ask the question and do a search. So you don't have a Congressman Santos situation. And, you know, if there's any chance that the person has misbehaved, that their other institutions are put on notice. So we stop this passing of the trash, and that has to be addressed. And yes, I agree, depending on what it is, there could be some cases we've had that are just sad occurrences that have happened that doesn't serve any purpose to put out in public, then fair enough, that there could be a determination about that. but most of these actions, I think, until bad behavior is named, particularly in the sexual arena, it's not going to stop. And, you know, I think it's really important to name it, publicize it, and hopefully stop it.
So maybe the last question I'll pitch to you, and I don't know if we'll have time for any questions. I see that there's a robust chat going on. I appreciate that. I'm interested in your respective takes on whether you think we will see more claims for defamation, more causes of action or lawsuits, I should say, against investigators. Two separate questions on either side. And
yeah, I think that there's going to be more claims for defamation. It's a tool. I think that, you know, it's the Johnny Depp tool. It's taken a lot of, you know, traction. It's gotten a lot. I find that a lot of people who, you know, particularly I was in Britain during the trial. We were asked to represent Amber Heard and didn't do it for various reasons, not because we thought the case didn't need attention, but, you know, she had gone through the process here in Britain. A very esteemed judge found Johnny Depp guilty of being a batterer, of being all sorts of nasty things that came up again in the States. So it was sad to see that here we had an articulate, informed, careful jurist here evaluate claims, find against Johnny Depp. Then he can go to America, and in a courtroom situation that seems out of control to me as a lawyer who litigates all the time, I was appalled to see what happened in that courtroom. And then, of course, he prevails. And we've heard, you know, the notion that if you have money, you can really destroy your partner by buying social, media bots, as he did. We're getting word, you know, Angelina Jolie is facing this with Brad Pitt. Brad Pitt wants to hire the same PR firm that Johnny Depp had. And the tool is, of course, a defamation tool. And they threaten this all the time. And, you know, it's one thing in Britain when if you lose and, you know, truth is your judge, whether you win these things or not, or truth that you can prove, it's one thing you can stop a lot of defamation claims because people have to pay damages to the other side in the court fees. But in the States, it's a free for all. And, you know, we have a lot of people who want to bring claims and they're terrified because people are going to fight back. Institutions, educational institutions, even professors who are on limited salaries, they threaten defamation claims and they're really tough. So I think we're in a very bad epoch right now, and we need to do something about that. But certainly it's a real fear.
Thank you. Sarah, I see a hand raised. Sarah, question?
Yeah, can you hear me?
Yes.
Okay, so I was curious. I apologize, I'm on my phone, so it's tiny, so I don't know the speaker name who was on the plaintiff's side. But she raised concerns about like Paul Weiss and defense firms coming in to do investigations. And she's obviously had very negative experiences in that regard. I'm wondering if she has had the same kind of or different experiences when it's not a defense firm who's typically defense litigating and then suddenly is supposedly independent investigator, but an independent firm like Amy Oppenheimer's firm, like, you know, your firm, Sue Ann's firm, that come in and, in my opinion, are a quite different animal, but I want her opinion.
Yeah, fair question, Sarah. We have not had that experience. You know, the firms that we're dealing with, they are often powerful and they hire really expensive counsel to do these investigations. They put a lot of money, as I said, millions and millions of dollars, and they use them often as weapons. So we have not, unfortunately, had that experience. We'd like to have Sue Ann firms, Amy's firm, that type of firm do it. But we have not been, we've not had that experience, sadly.
Well, in my opinion, that tells you something about those defendants, because I'm a workplace investigator now, but I was a defense side litigator for many years. I stopped litigating in 2019. But I would not have advised my client. I mean, I used to all the time, they would say, we want you to do the investigation, Sarah. We want your firm to do it. We trust you. I'm like, that's great, but that's a bad idea. Yeah. So that tells you something about the defendants that you're dealing with, in my opinion.
Exactly. It's true, but they're big players. And we have to go with, you know, the hand we're dealt with. And that's the hand we've been dealt with so far.
Thank you for that. So we have a 1 minute. Irma, do you want to bring us home?
Yeah, I think I'll just piggyback off the last comment, which is obviously as lawyers, we obviously have a duty when we serve in this capacity as advisors to the employer. For those of us who do that kind of work, obviously we have a duty of loyalty, a duty of zealous advocacy. but that we have to understand that that duty of loyalty and that duty of zealous advocacy does mean being reflective of the fact that these allegations that these things do happen in the workplace, and that our job sometimes as minimizing exposure is to reach resolution in a gracious way, in a way that allows everyone to be able to move on. I do have one public entity, high-level institution, who has clearly advised me they want to hear it from me straight. What do I think? You know, I don't serve as an investigator in those cases, but I advise them on it. And I certainly would want all my clients to feel they give it to us straight. What do we have to do? We don't care if we have to make public admissions that we could have done better, we didn't do right. The only way the organization heals and moves forward and gives true meaning to the organizational values is to do that. And I think we, obviously we're also in a weird way as lawyers, even compliance officers, ensuring that our clients are complying with their obligations, and not to have such a narrow view of we've got to beat down these other folks because, you know, we're going to pay millions. We may pay millions anyway, but we have to have healing and move forward if the allegations are in fact true, and we need to be open to the fact that the allegations may be true. And I want to say thanks for inviting me to participate. It's been a pleasure.
Me too. Here, here. Thank you.
Thank you both, Anne and Irma. Really, really insightful commentary. And back to you, David.
Back to me. I think back to Amy, probably.
Back to Amy. Okay. Thank you.
Okay, I think we're going on break, right? So we've got a 15-minute break at 11:15. We're going to have the last panel that Vita is leading, and is going to be about confidentiality, transparency, some of the issues that we were just discussing. So it should go nicely with everything that we've already talked about. See you all then.